Good afternoon. Thank you all very much for joining today's webinar. This hearing is in session, the board's role in school district hearings. We are so happy to have you with us. I'm Debbie Singizer, and I'm the Director of Board Services here at the Vermont School Boards Association. So as you know, one important role of school board members is to conduct quasi-judicial proceedings. School board members are asked to take on this function in cases that require that a complainant receive due process under the law. Examples of cases which may require due process are the non-renewal of a teacher contract, the dismissal of a principal, or student suspension or expulsion. Fortunately, these types of hearings involving school boards are infrequent. However, when there is one, the district has a lot at stake. Therefore, boards need to be prepared and know where to turn for support if they find themselves in this situation. So that is why we're so fortunate to have with us today 3 individuals who have legal expertise and personal experience with hearings. I'd like to introduce you to our panelists. The first is Pietro Lynn, a lawyer who works at Lynn, Blackman, and Mentinsky. Pietro has worked with school districts and boards for many years on a variety of issues, including labor and employment laws, board governance, and open meeting law. We also have Elizabeth Burles, who's chair of the Mount Ascutney School District and Vermont State Representative for Windsor 1. Elizabeth has 10 years of school board service, both at the district and supervisory union levels, and she served as a board chair on and off for the last 10 years. Jay Nichols is our executive director of Vermont Principals Association. Jay is an educational leadership consultant, college professor, and was Vermont's 2018 Superintendent of the Year. So thank you very much to our panelists for joining us today and for sharing your expertise and knowledge with us. And at this point, I'd like to hand it over to Pietro, who will get us started with a PowerPoint.
Great. So, and Debbie, can you see the screen at this point, this PowerPoint? Great. Yep. Okay, so hello to everybody. Thank you, and I'm always honored to be among such good company. And thanks to Jay, to Elizabeth, old friends both, and of course to VSBA for inviting us to do this work. So as Debbie said, we're here to talk about quasi-judicial proceedings, and thankfully for all of you, these are few and far between. But the first place to start when we consider quasi-judicial proceedings is, of course, movies. And you will see as we work our way through these slides that there are court/litigation movies, because why not? That I have included in the presentation. And being a big Ruth Bader Ginsburg fan, we start with the movie about her called On the Basis of Sex. So what is a quasi-judicial proceeding? So that is my hint to all of you. And as we go through, I'm going to leave it to you to know what movies they are. I ask you to write it down, and whoever has the most correct at the end wins a huge prize. And we'll think about what that might be later. So anyway, what are quasi-judicial proceedings? I'm not making this up. This is not something that we've dragged out of the common law. This is something that is defined under 1 VSA section 310(6), the open meeting laws. And what it tells us is that there is a quasi-judicial proceeding presided over by the board where one or more persons who are a party in the proceeding have rights that are going to be adjudicated. What does that mean? That means when there are parties before you, one of those parties at least will have a decision from you that decides something having to do with their rights. And we'll talk about with specificity what that is as we move along. 2, it's conducted in a way that all the parties have an opportunity to present evidence. What do I mean by that? Well, what the statute means is that these are not things where you sit there and you divine from the environment what you think it ought to be, or where you take information before you even sit to hear the evidence and you use that as the basis of your decision. No, what the statute specifically contemplates is that each side will present evidence, and what you will not do is consider evidence from outside the hearing in connection with the decision that you as a board must ultimately make as you adjudicate these rights. The parties have a right to a lawyer. We may want this to be an informal, amicable, collaborative process, but that is not what is contemplated by the statutes. What is contemplated is this system that we have in place for litigation generally, and that is something that we call an adversarial system. That is, and the concept behind an adversarial system of justice is that there will be two sides making arguments and presenting evidence against each other, and that from that conflict, truth emerges. And your jobs as finders of the fact, when you are engaged in this quasi-judicial function, is to decide what the facts are based upon these competing versions of reality that are presented to you by way of evidence and argument. The parties have a right to cross-examine witnesses. That's inherent in this concept of due process, right? So if a witness comes to testify, and there must be witnesses if it is a quasi-judicial proceeding, and witnesses come to the hearing and they sit before you, they are asked questions. That's how the evidence is presented. They don't just sit down and tell you a long narrative based on whatever comes into their head in the moment. And then there is cross-examination by the opposing party. And this can be, forgive me, a very uncomfortable process. People are discomforted by cross-examination, both the witness who must experience it and the people who must observe it. And, you know, my friend Jay was with me 8 days ago as we went to federal court on a case that is very important to all of us, because the parties opposing us sought to invalidate our HHB policies, the statewide policy. And I think what Jay can tell you, and Jay, I'll ask you to unmute for a second. What is that like? That experience of being there, the cross-examination? Is it uncomfortable? I mean, do our board members have to understand that this is something that you're just going to have to live with?
Yeah, I think that's exactly right, Pedro. It is uncomfortable, but it's also part of the job. And fortunately for board members, it doesn't occur very often. But when it does, you have to be ready for it and be ready to sit there and listen to both sides and then ascertain, you know, what the evidence shows you in terms of helping you make a decision as a collective board.
And Elizabeth, let me put kind of the same question to you. I know for a fact that you had to tolerate me in a quasi-judicial proceeding. And the question for you is, how did you experience that adversarial process coming to it from a board role, which is generally collaborative?
It's really hard to answer that question, Pietro, because we were caught up in so much. We were caught up in national press. We were caught up in not fully understanding the process, and press inquiries and communications from all over the place. And so the one thing that got us through was a leap of faith and trusting the process. And when we trusted you and trusted the process, we were very gratified by that. We learned a lot, and which we wouldn't have necessarily by not taking it seriously or not focusing on the actual process. But it was very rewarding to take part in that process.
Thank you. So let's go back to the slide. The final two items that are required by statute is you got to have a result that's in writing. It's, you know, sometimes boards would like to come out of executive session and say, we vote to fire Principal A. And the answer is no. If there is a quasi-judicial proceeding required by statute or common law, then what we need to do is we need to write a document that explains how we reached our decision. What are the facts? What is the law? And how do we apply the law to the facts that we have found? And then finally, a quasi-judicial proceeding contemplates that ultimately the decision, whatever it is, can be appealed to some higher authority. And I'm not talking about a theological issue. I'm talking about to some court of competent jurisdiction or some internal authority, but there must be a right of appeal. And what I know about boards is the right of appeal is to the Superior Court in Vermont, where on the record that has been created, the Superior Court has to decide two issues. One, was there evidence to support the decision made? And let me repeat that, not that you got it right? The question is never, did you get it right? The court on appeal just has to look at the record that has been created and decide, is there some evidence that is reasonable that a board could have concluded supported the decision made? And then the second issue is, was the process fundamentally fair? Not perfect, but was it fair? And if both of those items are satisfied, then the decision by you as a board will be sustained by the courts on appeal. So when do school boards have quasi-judicial meetings? And that's what they are. They are part of a meeting. Under the open meeting law, we have to warn quasi-judicial proceedings. We have to have an agenda, and where we have an agenda, we have to allow public comment before we commence what we are doing. But once we get into the quasi-judicial proceeding, that agenda item that identifies what we are going to be doing, then the public has no further role. This is not an opportunity for everybody to weigh in on whether we ought to terminate some employee or whether someone is a resident of the district. Once we commence this process, it is just you as board members and the parties. Those are the only ones who have speaking roles in this drama. And all of these sessions, the default is open session unless the statute says otherwise. And I'll give you all examples. Some years ago, I was representing Colchester School District, and the claim was that a hockey coach had behaved in a way that supported termination. And so we had a hearing. The hearing was open to the public. Channel 3 was there, the Burlington Free Press, hundreds of people from the community were all there. And the board had to sit and hear evidence and make a determination in the end as to whether there was just cause to support termination of this $3,000 a season hockey coach. And this is just an example because there was no statute that said otherwise. It was an open session, and you can imagine the amount of tumult and dislocation that kind of hearing can cause, particularly where you're dragging in students who have to serve as witnesses as to the alleged misconduct. And just
Pietro,
yeah, go ahead. Yep.
we have a question. Do you want to take questions now, or do you want to take them at one time?
No, let's do it. Go ahead.
Okay. A board member says, how would a chairperson handle a situation where it's clear that at a hearing that a board member has outside knowledge or has conversations with one side and may have bias?
Okay, so hold that thought. We're going to get to a slide that has that. It is an excellent question. Now, let me say this. We're looking at a photo here, and do we all know what movie this photo is from? The answer is none. It's a trick question. This is our Vermont Supreme Court. And in the end, all the questions that are appealable from the board to the Superior Court can go all the way to the Supreme Court. Some years ago, I participated in a decision in a case that went to the Vermont Supreme Court on appeal from the West Rutland School District, and it was arising from the termination of a principal. And the Vermont Supreme Court issued one of the seminal rulings on the question of bias of school board members, and we will talk about that in a moment. Okay, so the next slide, of course, we all recognize this picture, right? 12 angry men. And all I can say is I've tried about 150 jury trials in my lifetime. I've never had a case where it's just 12 men all in white shirts. I've never seen that before, and maybe that's a sign of progress in this country. So let's talk about what are the kinds of subject matter that will lead to these quasi-judicial functions. And I want to remind you, because I think in some areas we're really good at being formal, and then in other areas we're not quite so good at following the rules of the road. when it comes to quasi-judicial proceedings. So employee termination, I think we're outstanding at that because you always hire the lawyer and the lawyer says to you, like, this is the stuff you need to do and this is how we do it. And we all kind of get it and we follow the rules. But I bet we don't when it comes to residency hearings. And I bet we don't when it comes to expulsion hearings. And believe it or not, both of those are quasi-judicial proceedings that require us to follow the rules that I just spoke about. Right? Remember, everybody gets a lawyer if they want one. There's cross-examination. We present evidence. People testify, and they do it with questions. There is a record of what we've done so that in the event that somebody wants to appeal it, they can. Boy, that sounds like a lot, and it is. But if you're asking me what the law contemplates and requires, that's exactly it. And then, of course, there are grievances that come to you through the collective bargaining agreement, and those also are quasi-judicial proceedings. So employee termination, like it looks like a mini trial, but the bigger question is it an executive session or not? And this very dramatic photo comes from the filming of The Crucible. And of course, it doesn't look all that different from the 1950s version of 12 Angry Men, right? Like you got 3 angry men there who are making all the decisions, which demonstrates there wasn't as much progress as we would hope in those many years. That's that film. So let's talk about principles. In the termination of principles, it is open session, but only if both parties agree in writing. And that's a good thing. If you ask me, generally speaking, it is a wise thing to have these hearings in executive session if we can. Having participants there, people making noises or shouting or looking upset, I'm not sure that it really advances the interests of justice to have lots of observers. Superintendents, it must be an open session if we are terminating a superintendent, and teachers shall be in executive session unless the teacher requests otherwise in writing. Expulsion hearings. So I just want to remind you, remember one of the things that we talked about at the beginning was that there must be evidence that goes to the issues. We can't just, sort of intuit what the evidence is. It has to be presented. And it must be relevant to the inquiry that needs to be made in that hearing. And I want to remind all of us, because in my practice, as I wander around the state of Vermont, at least by telephone, what I discover is we oftentimes forget what the expulsion statute says. And if we don't know what it says, how can we properly perform our duties at an expulsion hearing? And this is what we have to remember. It's for the remainder of the school year or 90 days, whichever is longer. Whichever is shorter. What is the kind of stuff that gets you expelled? It's stuff that happens on school property where there is there's evidence of continued presence of the student would be harmful to the welfare of the school. So, right, having the student remain is harmful to the school itself, not the student. If it didn't happen on school property, then it's where there was direct harm to the welfare of the school, and that can be demonstrated by it happening someplace else. That might be hard to do. And then finally, if it's not on school property, but if it's and not part of a school activity, it's where the conduct can be shown to pose a clear and substantial interference with another student's equal access to educational programs. It is a very high burden to reach, and we must be mindful of that as we make these kinds of decisions. So residency hearings, right? And of course, all films that you have to talk about when it comes to courtroom dramas begin and end with My Cousin Vinny. And there we see 2 great actors in the midst of their performances for that great film. Residency hearings. Why do we do those? It's to determine whether a parent is a resident of the district. And we are making a determination about the rights of that family to send their student to our school. Evidence must be presented by the parties as to domicile, right? Where do you live? Where is the place where you have your center of gravity? Where do you keep your winter clothes in the summer? Where do you keep your old yearbooks? And that is all evidence that must be submitted to the board for a determination, and the board must issue a ruling in writing as we have earlier described. If we are going to strictly comply with the law, there's a mini trial. And oh, by the way, residency hearings are always, I'll say it again, always in open session. Why? Why? Because as a matter of law, any resident of the district can appeal a decision of the board, which is a very interesting concept. What that means is anybody who lives in your district can decide your decision that somebody is a resident is wrong and bring it to the Agency of Education, which is where we go on appeal. So let's think about other helpful hints from the Vermont Supreme Court about what is necessary and what are the constraints of a quasi-judicial proceeding. And of course, the picture here is of the late, great Paul Newman in the movie The Verdict. Paul Newman did a fabulous job in a case having to do with product liability, made some impassioned pleas to this jury. And those of you who may remember this movie or old enough to see this movie will remember he won a whopping verdict. Actually, it was an Catholic Church abuse case. That's right. My memory isn't as good as it ought to be. So here we are. So when you serve on it as a quasi-judicial body, the hearing must be fair and open. The key is there's an opportunity for the persons appearing before you to be heard and have an impartial decision maker. Your decision as a board, says the Vermont Supreme Court, must be based on, here are the words, admitted, competent, and material evidence. Let's unpack that for a minute. What do I mean by that? Admitted means that during the course of your hearing, somebody has to say, I move to admit, I want to admit, please admit this piece of evidence. And you as a board must make a decision to admit that evidence. Now, some boards will go so far as to delegate that responsibility to the board chair or to an attorney acting to support the board. But some bodies need to make that decision so that it is on the record admitted evidence. So what is competent evidence? Competent evidence is evidence that supports the claims, right? Competent and material evidence goes to the issues you have to decide, not some other thing, like I'm a bad person and therefore I must have done this bad thing I'm accused of. No, evidence as to the very issues you are deciding, which requires, as you can see, some level of discernment where you make decisions about what is competent and material to the issue you have to decide and what is irrelevant and not material to what you are deciding. It has to be trustworthy, reliable evidence, right? So then we get into issues of, well, what if I want to bring in a statement that I got from my Uncle Joe around this? Joe's not coming to testify, but I want to bring it in anyway. And those are hard questions for you as a finder of fact to decide what is trustworthy, what is reliable evidence, because the rules of evidence as we would use them in court don't apply, but they may provide guidance. You need to understand it's not a free-for-all. Everything doesn't come in. Whatever I want, if I'm a party to present to you, doesn't necessarily come in and may not be considered for you or by you in the decision that you ultimately issue. And this question of material evidence, again, if we focus on what is the question you have to answer, what is the legal issue, and what is the evidence that goes to that legal issue, not other irrelevant things. What about impartiality? Now, here we go. This is actually language that comes from that West Rutland School District case many years ago. And this question about impartiality is answered in part, right? And what the court said in that case is that that impartial or bias cannot be present. Partiality and bias must be avoided. And bias manifests itself in two forms. One is this concept of actual bias, and the other is the probability of bias. And now we're all scratching our heads and saying, what in the world does that mean? Well, probability of bias means that there's circumstances from which we could say, well, there probably is a bias, or there may be a bias. And the court in that West Rutland case said, no, probability of bias for school boards is not ever going to be a basis to disqualify them from making a decision. Put differently, if there is a probability of bias and you participate, you will not undermine the integrity of the ultimate decision that is issued. So really what we have to worry about is actual bias. And the question then becomes, what is it? Well, there was a case years ago where the union challenged the ability of a board member who was on the negotiating committee, who tried to negotiate really good terms against teachers into the contract. They argued this issue of probability of bias. You showed us you could not be fair. And the Vermont Supreme Court declined and said, no, there's no actual bias just because a board member engaged in one of its statutory obligations in negotiating a contract. Yes, that board member was adverse to the union during that proceeding, but that doesn't undermine the board member's ability to hear evidence and make a decision where it comes to the termination of a teacher. And here's the language that I thought also was helpful. We as board members know stuff. We can't always come to these proceedings as a tabula rasa, right, with no knowledge of anything. Now, I will tell you as a best practice tip, as much as we can do to shield ourselves from the specifics of something that may come to us on a quasi-judicial basis, sometimes it's impossible to avoid it. And this is what the court said: mere familiarity with the facts of the case gained by an agency, or in this case, a board, in the performance of its statutory role does not disqualify a decision maker. Let me say it differently. Knowing a bit about the issues coming before you does not necessarily disqualify you. You as a board have some things you must do. For example, in that West Rutland case, the board must, among other things, hear information about the principal from time to time, interact with the principal, and develop opinions about the performance of the principal, at least within the context of board meetings. And so any allegation that they knew too much by virtue of this interaction with the principal and drawing conclusions based on those interactions, the court said, is unavailing. Now, if we instead begin to investigate things on our own, or make ourselves witnesses in the underlying matter, then we run the risk of not being able to participate in the overall decision. And remember, like if there's a 5-person board and all 5 agree, it's not like we can say, oh, well, one person should have been disqualified, so therefore it's 4-0 and it's fine. If there is any taint to the process itself is undermined and is reversed by a court on appeal. Prior involvement in the subject matter of the hearing will not work as a judicial disqualification. And so again, this gives you some latitude, but it is not limitless. And here's one of the cases, and this picture from one of my favorite court movies, Philadelphia, with Tom Hanks and oh my God, this is terrible. Yeah, so this is just a function of my Denzel Washington, one of my very favorite actors. And one of the great lines from this movie, Philadelphia, is when Tom Hanks walks into Denzel Washington's office and he begins to tell his story. And Denzel Washington turns to him and says, wait a second, explain it to me like I'm a 6-year-old. And you know what? That if I ever meet with clients, the first thing I tell them is explain it to me like I am a 6-year-old. So going back to this, so where does it become actual bias? One of the cases in Vermont where it was clear there was actual bias was not in the school board context. In Vermont, we just don't have that many school board cases that have gone to the Supreme Court. But in this one, it was the chair of the DRB, the Design Review Board. And that he had been earlier attacked the nonprofit environmental organization that would then appeared in front of him on a permit application and opposed the permit. The permit was granted, and the nonprofit argued that he had already demonstrated bias against him by virtue of his earlier public statements. And the court agreed there is a line, and when you have articulated with specificity your feelings about a party or an issue before it comes before you, then the risk exists, significant risk, that you cannot serve in a quasi-judicial capacity. So what does that mean here? And now I'm going to stop talking a little bit and invite my panelists to talk on these issues. But what do we do about the board member who runs on the concept that the principal is not performing and needs to be terminated? And I turn to Elizabeth and Jay. What is it too much? What do we do? How do we persuade people that they should not participate?
I can go first. I actually went through this issue with a school board member whose child was a teacher that we were having the potential of determining that person was no longer going to be an employee. It's a little bit different because the person was a probationary teacher, but the rest of the board wanted this one board member to recluse themselves from the situation, and the person refused to do so. And so we explained to that board member and the rest of the board that, should this go beyond this, you're putting the board in an untenable situation. And so the board voted to recluse the person, asked him to leave the meeting. He left quite angrily. I don't know if that was the correct way to do it, Pietro, but that's essentially what we did. It was a 5-member board. It was back when it was a town school district. And so the board proceeded to move forward from there without that board member present. And so if he had challenged it and refused to leave, I'm not really sure what we would have done.
That's fascinating. And it raises a really good question. What do we do with board members who will not leave? What if that person had not? And I guess the only way that I think we could get around it is if the board voted to create a committee, and the committee's role would be to hear the matter and to act as the quasi-judicial body. That's me thinking off the top of my head, but I think it's probably the only way to get around what I'll call the rogue board member problem. And what about this, Elizabeth, for you as a board chair? How do we deal with board members who engage in conversation with other constituents, as members of their community, about things or people who may be the subject of some quasi-judicial proceeding?
My answer to that question is I don't know. I think as board chair, you can ask them not to. You can ask the lawyer to come down on them, and often that scares them enough that they'll knock it off. But that may be after the damage is already done.
It's incredibly challenging, and even as a board chair, Elizabeth, you are one of the more articulate, thoughtful board chairs I've ever encountered, and I think what you would agree with me is that getting some fellow politician to stop talking is sometimes hard.
Yeah, definitely.
So that's the challenge.
Pedro, before you go on, because I think it's just a perfect time for Herb's question.
Yeah.
He mentioned, I don't have it in front of me, but something along the lines of, when somebody calls you, should you be taking notes and stuff, or should you just push it back up the administrative chain of command? And that is the answer. If you have a person who's calling you as a board member with a complaint about somebody in the school system, ask them to follow the chain of command and let them know that, should there be an appeal down the road, this could come back to me and I would have to serve on this as a quasi judicial board member. And because of that, I don't want to hear, all of the information. It's not really appropriate for me to have that. Instead, go through, whether it be the teacher, the principal, the superintendent, follow that process, and it ends up back up at the board. At least I can be in a position to be an impartial judge on that situation.
Yeah, but that isn't contrary to what Pietro said in the slide before, which is having information doesn't necessarily disqualify you from participating in the process.
Yeah, that's true. But what you don't want to be is the investigator yourself. So if I call you up,
Right.
for example, and you're a board member, and I say, I've really got a problem with the principal, and I'm going to lay out all this stuff for you, what you should do as a board member is say you need to contact the superintendent.
Yeah, right.
That's what I mean by that. I think that's what Herb's asking.
Okay.
Yeah, and so look, I mean, it's one of those wonderful situations where both our panelists are absolutely correct. Is it the end of the story and you got to recuse yourself if somebody is complaining to you about the principal and later there's a termination proceeding? Probably not. But best practice here is, why risk it? Like if all of a sudden this person is saying to you things that, and they are a witness in the proceeding that you have subsequently, and then they say things that are inconsistent with what they told you earlier, guess what? You're a witness. And what you can't do is come to this proceeding and say, well, everybody, guess what? He told me something different outside of this hearing, and therefore we can't believe what he said or she said in the hearing, because then we're taking information from outside the proceeding and we are actually a witness and we should have been participating and we shouldn't be involved in the deliberations if we are a witness. So it's challenging. And like 9 times out of 10, maybe 99 out of 100, you wouldn't have that situation and we don't need to worry about it. But again, the best practice is, insulate yourself from the infection of bias, too much information. Okay, so the next slide. So what does this process look like? And this is it is like a mini trial. And of course, the trial, this is from a movie that, and I'm not going to say the names, right, because we're supposed to be writing these down, but Legally Blonde. So look, so this is this is my advertisement, right? Hire a lawyer. If you're going to do this, it's just too, some of these things, it's too complicated. You just can't do it on your own. Hire a lawyer for the board to support the board. Hire a lawyer to support the administration, because I don't know how many of your administrators are good at cross-examination or direct examination for that matter, but those skills are significant and they have a role in the context of a true adversarial proceeding in front of a board. You've got to be able to do it. And asking your administrators to do it in some instances is an unfair burden, just as asking you to navigate these difficult shoals without a lawyer can sometimes be a bit too much. And there's some exceptions, and we'll get there in a moment. I am not angling for work. There are ways for you to do it without me. So we need to be prepared that the entire hearing is recorded, even the ones that we're going to do that are fairly what I'll characterize as informal, and how we get to informal from formal I'll talk about in a moment. But we should, as best practice, record quasi-judicial proceedings so that there is no misunderstanding about who said what, and if there is ever a time that it is going to be significant on review, we will have the information available to us verbatim. We need to make sure that due process is followed. Remember what I said earlier, due process is about this. You got to know the nature of the allegations against you, so there's no mystery. You've got to be given a full and fair opportunity to present your side, and then you have a right to a fair tribunal that issues a decision. Well, part of that is putting the parties on notice. There must be a document that describes the nature of the dispute. What is it that you will be deciding as a quasi-judicial body? If that document is not shared with both parties, we are doing something wrong. There is a fatal procedural substantive mistake. We also can't have surprise evidence, right? Like, we don't go to these hearings and spring things on people and expect us to withstand judicial scrutiny. right? Part of due process is understanding the evidence against you so that you can rebut that evidence if you need to. This is particularly true when we get to termination hearings and other hearings that require a high level of formality. And so we have to think about making sure that everything that is going to be used at hearing is produced to both sides. How do we-
Pietro,
Yeah, go
I
ahead.
have 4 questions. I have 4 questions in queue. Do you want to take them now or do you want to wait until a certain point?
Go for it.
Okay, the first one is if the hearing is allowed to be an executive session, how detailed does your agenda need to be in identifying the purpose of the executive session? If we cite statute, which would it be? And would we need to allow for public input prior to the start? In which case, how much information are we expected to include on the agenda?
Yeah, so remember, we were talking, let's say it's an expulsion hearing, that's an easy one. I think what we would do is we would identify expulsion hearing for a student, and that would be on the agenda. But this is sort of leaking into my open meeting law training that I do sometimes. And what I would say is this: when we create agendas, what we do is we identify with specificity what we're going to talk about, at least to a level where members of the community can challenge it if they want to. What I don't like is, personnel matter. Well, there are lots of personnel matters that can and should be described and discussed in public. There's some that should not. And so what we need to do, again, if it's going to be a quasi-judicial function and a hearing, then we need to describe the kind of function, termination hearing for a teacher, so that people understand why we're going into executive session. Other questions?
Yes. How is it determined whether the local district board or the supervisory union board is the appropriate body to conduct a particular hearing? Is the supervisory union board ever a venue for hearing an appeal on a local school board decision?
Yeah, so that's, we got smart people in the audience. That's a very, very good question. The short answer is this. The supervisory union employs all of your central office folks. It employs your paras generally, your paras and your special education teachers. And as the employer, they're the ones who would make decisions around these quasi-judicial functions having to do with termination. What they would never do is have an expulsion hearing. And what they would never do is serve as an appellate body. So the district gets all the student-related stuff, all the principal termination or discipline issues, all the teacher hiring and firing issues. And so it just depends who the employer is and where the student goes to school. And they would get the residency. The district would get the residency determination because it is a district school. Other questions?
Great. The next one's an easy one because it's a statement. Kind of is another problem that the complaining citizen, and this is regarding, I think, a board member knowing too much early on. It says, is another problem that the complaining citizen may tell the board member something that may be inadmissible in the quasi-judicial proceeding, like what their brother-in-law told them.
Smarty pants, absolutely, right? Like, that's brilliant. Yes. There are probably 100 other reasons we're not thinking of why it's really bad to know a lot of stuff about an issue if you have to go through this process. And of course, look, I mean, at some level, maybe we can pretend we don't know. Maybe you're better than me and you can just, do a brain wipe and you just come clean to this and you won't mention it when you're deliberating. But I would suggest to all of you, better not to know, and that way you don't have to do that brain wipe that you can do and I can't. Any other questions that you have for me? I think it's Carrie, right?
Yes. I have 2 more now. If we're recording, and 3 more. If we're recording quasi-judicial hearings, how are these being kept? Is it in executive session? Is that recording ever posted publicly?
So, yeah, that's a really good question. So if it's in executive session, it is private until it is public. And what do I mean by that? I mean, the decision that is issued is a public document. The minute you issue it, it is a public document. So all, if it's a termination hearing, all the bad things that you write about the employee you're terminating, that all becomes public record, and anybody who wants it can ask for it and get it. And the actual hearing itself remains an executive session item until somebody appeals it. The moment they appeal it, they will get a transcript and it will go to the Superior Court, where it will be a public record. So yes, it gets converted to a public record at some time, depending on whether an appeal is taken.
Great. Is the guidance you're providing here applicable to the HHB board appeal hearings for school district determinations of HHB policy violations?
Yeah,
If
so
not, will you touch on that at any point? I ask because the documentation from, I think it's supposed to be Visbit, but it has an extra I on this, is quite old and references guidance from 2015.
yeah, so it really hasn't changed since 2015. So rest assured, the Visbit information is current and accurate. Well, remember this: it is a quasi judicial proceeding when it comes to the appeal on an HHB determination, but the difference is you are not accepting evidence. Remember, you are making a decision based on the record that was created below. So remember when I was talking about what the Superior Court does? It answers two fundamental questions. Is there some evidence to support the decision? And was the process fair? That's what you're doing when you sit on one of those HHB appeals. Next question.
Okay, I'm gonna skip to the one that just came in because it's also about HHB. It says follow up to HHB question. Guidance says no new evidence, not retrying the finding, etc. This webinar says evidence should be presented, witnesses called, etc. Does
Yeah.
that make
Yeah,
sense to you?
so remember, it is an abuse of discretion review for HHB. You are the appellate court. You accept no new evidence, and that is so hard for boards. You want to get back in and relitigate and redecide and all of that, and you want to talk about the quality of the evidence and whether they got it right. No. The only decision that you as a board must make on the HHB appeal is, was the process fair, or was there like just some fundamental problem with it that made it totally unreliable? And then the second question is there, could some reasonable person make a decision that supported this based on the evidence, right? And that's different than, yeah, I disagree. You can disagree with what was decided and still affirm the decision by the administration on the HHB appeal.
Okay. What district is involved in a hearing when the student is tuition ED out of the district where the family resides?
Yeah, so I guess I'm confused, meaning that if the student is from an expulsion hearing for a student from a different school or a different district, like a choice district. Yeah,
I think this is a residency one, Pietro. So use one of my towns. So I'm from Berkshire. I have a kid that goes to a high school, and who's the board oversees whether or not that kid is a resident of Berkshire, and that would be the Berkshire board in that case. So it's the board where the kid is saying they reside, or the family says they reside.
Yep.
Okay. Public document. Okay, so this one says, this is the last question. Public document even for, so they're talking about the recording, and they said public document even for student expulsion hearings. I think they're saying, would the recording from the student expulsion hearing still be a public document?
If it was appealed by the student to the Superior Court, it would be the burden of the student making the appeal, or the parent making the appeal, to seal the record, to keep it private. If they do not, it is a public record. Whatever lands in the Superior Court, absent a motion to keep it under seal, will be a public record, and anybody who wants to can go down to the courthouse and paw through the transcript and see whatever they like. So yes.
Okay, great. That's all the questions we have at this time.
No, okay. So let's get back to the to the slides. So look, we want these things to be longer, not shorter. Yeah, remember that West Rutland case I told you about? I was not involved in the actual trial of that case. I came in when it was appealed, and what I can tell you is that they sat for 5 days. 5 days. It's insane. That is a very long time for a volunteer board to sit and listen to evidence. And what I would say to you is this: we don't want that. We want to streamline the process. And so what we need to do is we need to get pre-filed testimony if that's necessary. What that means is that we get sworn affidavits that say, this is my side of the story. You submit it to the board, you send a copy to the other side, and then you allow cross-examination. Right? Elizabeth, that's what we did when we had our case. Let me ask you, was it effective to do it that way, or does somebody lose their thunder by, steal their thunder by not getting a chance to personally tell their story?
I felt as a quasi-judicial member that it was really fair. I guess that's really the bottom line, because both sides had the same guidelines, and it did save us a lot of time by having the pre-filed testimony. The only problem, as far as I can tell, is the question of whether all the board members are reading the pre-filed testimony.
I know you did, and how did that work in terms of your feeling of preparedness coming into the hearing?
How did reading it in advance? I mean, I'm not a good person to ask because I'm an anal record keeper, and I dive deep into those things. So I read through the testimony and wrote my own questions, and then I was able to make note of the answers as they came up during the actual testimony, as you know. And so that was the part of the whole process that I really enjoyed the most, actually, was comparing the pre-filed testimony to what was being said in real life, and being able to kind of fill in the blanks. I really enjoyed that part. The rest of it was very stressful. That wasn't.
Okay, so let's go back. So another thing we can do to shorten it up is put on time limits. One of the things we know is that oftentimes the presentation expands and contracts in direct proportion to the amount of time that we give people. And there's nothing to focus the mind like a specific amount of time, and then people get that stuff in. So that's one of the things that I recommend. Filing stipulations. What are the things we can agree to before we get to hearing, so that we know what is in dispute? It's a little bit like the Title IX work that we do. Those of you who are board members may not know it, but those of you, and I saw that there are a lot of administrators here who are listening in, you know that the work we do in Title IX is the investigator identifies the areas where there's agreement and the areas where there's disagreement, so we can be very focused on those specific areas. That can save time. Do it fast. And so you'll see my slide. It says, schedule the hearing ASAP. Justice delayed is justice denied. And the problem is this: the Vermont Supreme Court has been very clear with us that what we can't do is just put somebody on paid administrative leave forever, right? That is akin to firing someone, says the Vermont Supreme Court. And so we need to get to the issue as soon as we reasonably can. I'm not telling you to rush headlong into anything, but what I am telling you is the concept of interminable, indefinite delay is not a solution for you if we're worried about due process and fairness. And then there's the final piece, which is this: maybe we don't have to do all of this. Maybe there are other ways to do this if both parties agree. And that's really that's us being practical. I told you what the law requires, but then maybe we can find a way to opt out. And the way we opt out is to get people to waive their rights, because it's good for everybody. And we do it in writing, so there's no question later on. You hear, this is the Thurgood Marshall story. which is an excellent film. I commend it to all of you. But here's the letter, right? We're having an expulsion hearing soon. I want to avoid a super complicated process that'll definitely require lawyers. Let's do it this way. And describe how you want to do it, right? Like you tell your side of the story, we'll tell our side. We're not going to ask each other questions. The board can ask questions of us, and then the board decides. And once you've described it, you say, okay, I need you to confirm it is acceptable by sending me an email saying so. Right? And if we can get that, then we get to do it the way we've described. And then we don't have to worry about complaints later on about due process. And I'll say it again, this isn't taking advantage of somebody. This is saying to somebody, you know what? We don't want you to have to hire a lawyer. We don't want to have an unfair advantage by having a lawyer and you not having one. Let's do this in a way that is fair and reasonable and gets the information to the board, albeit in a way that is not a slave to the formality of due process that we've just been discussing.
Hey, George.
So I got to jump in and just
Go
let
ahead.
you know that we're pushing up against the 1 p.m. time. So go ahead, Jay.
I was just going to say that this is particularly effective when we're talking about student expulsion hearings, because the board and the school administration, they want the kid to get an education as well. So I think it's a little different when it comes to like a termination of a principal or a termination of a teacher. But for student expulsion hearings and things along those lines, residency hearings, a lot of times this works.
So, and when doesn't it matter if we get it wrong? Isn't that a strange thing for your lawyer to be telling you? Like, when don't we care? And here's the answer as with the picture from maybe the greatest courtroom movie ever, To Kill a Mockingbird, with one of my favorites, Gregory Peck. So residency hearings and grievance determinations, both of them are not final and binding. Both of them have de novo hearings afterwards, meaning that you start from scratch. And so if we don't get it right in a residency hearing and we decide against the parents and they appeal, it's not to the court, it's to the agency of education, and there's a whole new trial. So if we get it wrong, whatever. And the same for a grievance determination, right? Like if we go informal, we don't follow the process that I've talked about, it looks much more like a dueling presentations. So what? They get to go to an arbitrator de novo, let the arbitrator decide. Yeah, so we're not going to talk about this. We talked about it before. Remember, we got to worry about reliable evidence. We have to make sure that we get this right. When we do this, we got to make sure that it's fair, the evidence. The issue is this: can you cross-examine the party presenting the evidence? And so if we have somebody saying, here's a statement from a kid who's not going to come here, you can't cross-examine a statement. So you as a board probably ought not consider that statement. You as a board ought to require direct witness testimony. What they saw, what they heard, what they sensed, those are all things that are reliable. A statement signed by somebody who is not there and can't be cross-examined, not reliable. The burden of proof, somebody asked that at one of the questions in the lead up here. This is not a criminal proceeding. This is not beyond a reasonable doubt. It's not. It's just a preponderance of the evidence. And people ask me sometimes, like, what does that mean by a preponderance of the evidence? The answer is just enough. Just 51% likely true. And if you get to that tick over 50%, maybe 50.1%, that's enough to have proven that fact true. And that's the exercise you have to follow when you do this work. You have to sit there and say, all right, what are the things that need to be proven? And have each one of those facts been proven more likely than not? Just, like if we think about the scales, right, just one makes slightly more down weight. And by the way, one of the mistakes that we often make is that we go, oh, well, there are 3 witnesses who said this and 1 witness who said that, and therefore 3 beats 1. When I've tried cases, jury cases, one of the things the courts always tell the jurors before they deliberate is this: witnesses are to be weighed, not counted, right? Like we value their testimony based on their credibility and persuasiveness, not on their number. You can have 3 bad witnesses who don't do anything. So as we finish up, let's talk very briefly about deliberative session. That is not a meeting, right? We don't have an agenda for deliberative session. What we have is when you're done with your hearing, your quasi-judicial hearing, you adjourn to deliberative session. And deliberative session is the place where you haggle about what you think happened, you build the consensus, and the majority wins, whatever it is. And then you sign that written decision, and you have an ability to go back and forth as you write this document, right? Making changes, making suggestions. But in the end, like a court, you have to reach a point where a majority believes one thing or another and signs off on it. Okay, so those are the things I wanted to say for you and say to you all. And the question is this, Debbie, do we have a few moments for our panelists to just give some, sort of closing remarks on these issues?
We do.
All right, I'm going to be quiet and I'm going to hit my mic and mute.
So Jay or Elizabeth?
Elizabeth, go ahead.
I actually have a question for you, Pietro.
Oh, I guess I won't be quiet.
Now what was it? When you come out with your written decision, does that have to include the vote count?
It must indicate that, yes, we have to stand, and there can be a dissent. The people who disagree can write their own decision about why the majority got it wrong. But the people who dissent don't have to sign, but the people who agree all have to sign.
Okay, thank you.
Or they have to agree that the chair will sign for them.
Thanks.
Yeah, the only thing I would add to this conversation at all, Debbie, is I thought Pietro did a great job. Is just, especially for superintendents and board chairs that are out there, get legal counsel. Even if you decided that it's a student type issue and you're not going to be using lawyers and the parents aren't going to be using lawyers, just make sure, especially if it's your first or second time going through this, that you talk to counsel and help them, have them help you make sure that you're following the process. It's all about the process, doing it correctly, and take the time to do it correctly and get legal counsel. Don't just try to do it on your own. That would be the only advice I'd give.
I also want to ask you, Pietro, just to clarify, those 4 circumstances are the only 4 circumstances under which this applies, right? Or these rules apply.
Elizabeth, there may be other circumstances arising from contract or other circumstances, but like if you're asking me when was the last time I saw something outside those 4, it's been decades.
Well, I guess earlier this year, as a legislator who's also a school board member, I had to undergo a discussion about whether I had a conflict of interest remaining on the school board. And if it was supposed to fall into this structure, we failed miserably, but because there was no written conclusion, we didn't follow any of this stuff. But I think that the hearing that we did have also doesn't fall into these 4 categories at all.
So let me respond to that. Remember, the very first item is that it has to be an adjudication of rights. The board has no control over your right to be a board member, right? That's one of the either the great strengths or the great
weaknesses the thing,
of being
right?
on a board. Yeah, they could say yes, you have a conflict, and you could say thanks, but I'm going to do it anyway.
Yeah, as an elected official, as an elected school board member, just because somebody doesn't agree with you or because they think that you have some conflict, doesn't mean that you're just automatically excluded from the board and you can't participate in one of these processes. That's not the case at all. It's pretty hard not to have a conflict of interest in Vermont in many cases because we're so small. Every member is related to people in the community, and that's just the reality.
Yeah.
I mean, Elizabeth, I guess what I would say to you is this: it was a political process that you participated in. It was not an adjudication of rights.
Right, right. That is a great thing to remember. And so thank you. This has been really helpful.
And Pedro, I got a text from one of the administrators that's on the call asking about clarity on the student expulsion. And correct me if I'm wrong, but what the law says is expulsion can be 90 days or the end of the school year, whatever is longer. Somebody
Yeah.
thought said shorter. It's whatever's longer, unless it's a gun-free schools act thing, which could be up to 1 calendar year, right?
Yeah, so it's remainder of the school year or up to 90 school days, whichever is longer.
The few couple of really quick things that I wanted to say have to do with the kind of human and not procedural side of this. One thing is that, you know, a lot of these are not stressful, but some of them are. And as Pietro and Jay both said, these are really rare procedures anyway. But being prepared is definitely helps, and understanding what the procedure entails takes away a fear factor. Which you already said, Pietro, but local events do not necessarily have anything to do with the SU board, and which can create an awkwardness. If you are also, you know, a member of the SU board, and have a plan to respond to communications, a plan that includes your lawyer, and figure out when to include your lawyer in the communications, but also have pat answers for members of the public, and be really well versed in open meeting law, which is key, because knowing when you can talk to each other and when you can't about the matter at hand is really important. And also, don't overburden your lawyer. Thank you so much for including me on this. I really appreciate the opportunity.
Thank you,
Yeah.
Debbie, also. Very grateful.
Thank you all of you, Jay, Elizabeth, and Pietro, for your time and sharing your experience as well as your expertise. And thank you very much to our participants. We had very few people drop off, even though we ran over. So that means that there's definitely interest in this topic. And so thank you for tuning in today. For those of you who have not registered for our annual conference, it's coming right up. So please take a minute to do that. Right now, there's the QR code. You can just scan it and it takes you right to the registration page. We look forward to having you at Lake Maury. We look forward to seeing you all at the next webinar, the next VSBA webinar. And keep an eye on your weekly emails on Tuesdays for information about upcoming events that we are organizing. So thank you again, everybody, and have a great afternoon. Carrie, you want to stop recording?